Thank you so much for coming to tonight's Notable Neighbors program. My name is Erin Payton, and I'm the Executive Director of the 19th Century Charitable Association, which is located in Oak Park, Illinois. We're in for another great program tonight, and I'm so happy you're all here. Before we start, I just want to let you know a few things. At some point during the program, you might have a question spark in your mind or a comment, and you can go ahead and leave those either in our Q&A field or in our chat. And if there's time at the end of the program, we'll get to your question and we'll actually be able to unmute you and you can ask the two discussers the question yourself. That's about it. Enjoy the program. And I'm going to bring to the show Marianne Porucznik. Hi, Marianne.
Hi, Erin. And hello, everybody. For those of you that are unfamiliar with this series, the Notable Neighbors interviews were the brainchild of 19th Century Charitable Association President Al Parcham, who realized that the folks down the block, across the street, or behind the alley, might be really talented people who other people ought to know about. So the purpose of these interviews is to introduce these individuals to a wider audience. And I do want to encourage you, if you, in listening tonight, think of someone whom you know, who's a neighbor, who you think would be a great interview, please nominate them. Now, tonight, I'm going to be talking with Linda Coberly, who is not my neighbor, but until recently, she was Al Parcham's neighbor. And I'm really excited to do this because she is, she's just a fascinating person and has a really interesting stories to share. Linda is an attorney and an activist, a managing partner at Winston and Strawn LLP's Chicago office. She is been named as one of the 50 most powerful women in Chicago, and has won numerous awards that recognize not only her commitment to advancing the empowerment of women, but also her efforts in championing diversity, inclusion, immigrant justice, and human rights. She was part of a team of Winston lawyers who were actively involved in the push for ratification of the Equal Rights Amendment in Illinois, and has continued her involvement as chair of the National ERA Coalition's Legal Task Force. So I want to welcome Linda Coberly.
Hello.
Oh, it's so good to see you again.
It's good to see you too, and hello, neighbors.
So let's start with a little bit about this Oak Park neighbor. I hear you've been voted a lifetime citizen of the 700 block of Elmwood. Is that right?
Well, that I hope is right, and I hope that is an honor that I will carry for a long time. That's an important one for me. I lived on the 700 block of North Elmwood for almost exactly 20 years, and moved in the summer of 2019 downtown. So I'm now not that far away, but I do enjoy being on the block email list and come for block parties and love my friends on the 700 block of North Elmwood.
Well, and when the block parties start up again, we'll look for you.
Well, yeah, I will be there. And Al was our neighbor across the street for a long, long time, and he saw my kids be born and grow up, and he and Georgia are wonderful old friends of our family, and so is everyone else on the block. So.
And I hear you have a birthday to celebrate today too.
I do, because today is the 18th birthday of my younger daughter, Isabel.
So congratulations to Isabel. And congratulations to her mom, who is this powerful. So what drew you to the law as a career? Was a role model that you had in your family or anything?
No, actually, I'm not. I'm a first generation lawyer. There were no other lawyers in my family before I went to law school. I actually came to it in a way that I would never recommend that anyone come to law school, which is I didn't really know if I wanted to be a lawyer. I did think I would like law school. I had majored in religion in college and loved that, and thought about going to graduate school, but I thought I needed some time to work and make some money and build up some money for grad school. And so I got a job in New York City. I worked for MetLife for 3 years. And at the end of that time, I did decide I wanted to go to law school or graduate school. I wasn't sure which, so I took both the GRE and the LSAT at the same time and considered the options and decided to apply to law school. And I don't really think at that time that I knew what a lawyer did all day. I knew my parents said, I was in theater in college, and my parents always said that they didn't think I actually wanted to be a lawyer. They just thought I wanted to be on LA Law. And that's kind of all I knew about what it was like to be a lawyer. It turns out that I really love being a lawyer, but I feel I loved law school, but I also love being a lawyer. And I feel pretty fortunate that that's the case, because you do acquire a lot of debt when you're in law school. So when I'm talking to law students today, I do encourage them to make really darn sure that that's what they want to do with their lives. But for me, it's been a fantastic career, and I really love what I do.
So I'd like to start with a piece of your law history that I found absolutely fascinating. You served as a law clerk to Supreme Court Justice, Associate Justice Stephen Breyer.
I did.
Not only that, but you were in the same class of law clerks as Amy Coney Barrett, who is now the newest, youngest Associate Justice on the court. So I want to know, what does a law clerk for a Supreme Court justice do? And did you have any input in specific cases, or got any stories to tell?
I have lots of stories. So a law clerk's job, there are a couple of important functions of the law clerks. In the Supreme Court, each justice has 4 law clerks, and retired justices also have law clerks. So there's still a law clerk for Justice O'Connor, for example, and they're shared with the other chambers. So in our chambers, we had 4 law clerks plus one who was at that time clerking for Harry Blackman. So it's a 1-year job. And it is usually people who are fairly recently out of law school. I was a little bit older for 2 reasons, actually. I had taken, as I mentioned, a couple of years between college and law school. I also practiced law in Chicago for a couple of years before I got the job with the Supreme Court. So I was a little bit older than most of the law clerks. When we started our clerkships, it was over the summer, and the justices were not really around very much. They tend to all come back on the first Monday in October. And actually they show up the prior month because they have a really important conference where they consider all the petitions for review that have been filed over the summer. So it's a really big stack of petitions. There are about 10,000 petitions for review. It's called certiorari, that are filed in the Supreme Court every year. And the court hears between 50 and 80 cases. So one of the most important jobs of the law clerk is to work on and process all of these petitions for certiorari. So you have to read them, analyze them, draft a memo. The memos for most clerks actually go to all the justices and recommend whether the court should accept review in a case. And so that's how we really started. And that continued to be an important part of the job throughout the entire year. And then we also helped the justices prepare for arguments and drafted opinions. They decided the cases, and it was always made very clear to us that they were the ones deciding the cases, but we drafted those opinions and helped them perfect them before they were sent out for publication.
So do I understand you right? Now, Justice Breyer had 4 law clerks, you said?
Yes. Mm-hmm.
And you all lasted for just 1 year?
All of us lasted for just 1 year.
That's an incredible amount of turnover.
Oh, well, and I honestly, I think it's partly to keep the clerks terrified, right? So you really don't want to make a mistake, and you show up for work the first day and see those big white steps and think, how on earth did I get this job? And it feels very serious. It feels very grave. By the end of the year, it feels almost like a family in that building. It's actually a pretty small, it's a really grand building, but it's a pretty small workforce in the building. They're just the justices, the secretaries, the clerks, and everyone gets to know each other pretty well.
So how on earth did you get the job? I mean, is there an application form that you fill out?
You typically law students, at least at that time, law students applied for clerkships in their 2nd year of law school and for Supreme Court clerkships in their 3rd year of law school. So I had sent out all my applications to the justices. I did a clerkship on the DC Circuit, which is the Federal Court of Appeals in Washington, DC, for Douglas Ginsburg, right after law school. And during that clerkship, I did get a couple of interviews. I interviewed with Justice Breyer, and I interviewed with Justice Souter. And my interview with him was one of the most fascinating with Souter was one of the most fascinating experiences of my life. We talked for an hour and 45 minutes, I think, and we talked about religion and law and things that were of mutual interest to us. And it was just completely fascinating. And I didn't get the job. My interview with Justice Breyer was very short because he had just given his 4th spot for that term to a guy named Neil Katyal, who, if you have been watching MSNBC for the last 3 weeks, is the Supreme Court advocate who speaks on Zoom from his basement about what's happening in the litigation. And he was the acting Solicitor General for a period of time. So Neil Katyal I like to say Neil Katyal took my job, but he took the 4th spot. And so Justice Breyer we spent 15 minutes together, and he spent most of that time talking about how he didn't have a job to offer me. And did I want to apply in the future? And originally I did, but then, my then husband and I decided we really wanted to kind of get on with life rather than just hanging around Washington on the off chance I would get a Supreme Court clerkship a year later. So we did move back to Chicago. And it was a couple years later that my Judge Ginsburg, gave me a call and he said, I'm having lunch with Steve Breyer next week. Do you want me to put in a good word for you? And it was a great time for us to move back to Washington. And so I said yes. And I got a call from Justice Breyer and I got the job. So by the time I showed up, I had spent like 15 minutes and 30 seconds talking with Justice Breyer. And that was about it. But I obviously got to know him very well when I was working there.
So what is it like? What are the justices like?
Well, one of the things that I think law clerks end up realizing, and most of the public does not, is that it is a very small work environment. And the justices are friends with each other, all of them. And I mean, we've all heard about the famous friendship between Justice Scalia and Justice Ginsburg, and they were very close. But the justices have meals together. It's one kind of tradition they have is before the State of the Union, they all have dinner together at the court, and they have lots of wine, and then they walk over together to the Congress to sit for the State of the Union, which is why that one year that Justice Ginsburg fell asleep, she admitted in an interview later that she'd had too much to drink. But they're friends, and they enjoy each other, and they're very collegial. So even when the cases were really contentious, the justices have the long view because they're going to be working together for literally their entire lives. And the law clerks are the ones who have a tendency to get very partisan and fight with each other. And there's a little bit more tension among the law clerks. Now, my year, we happened to have a lack of really controversial cases. So the law clerks also got along really well. But what really amazed me was the personalities of the justices and how much they enjoyed each other, all of them.
That's interesting to hear because they've all been nominated by different parties over the year, right. And they each have such different backgrounds and from different parts of the country. So to see a meshing like that is, I wonder if it comes with time, just because they do have these lifetime appointments.
I think that's what leads to it. To be honest, I mean, they have very different perspectives. And of course, they disagree frequently and write these nasty dissents at each other. But they do have an appreciation of the length of their time together. One other thing is they actually don't have very different backgrounds. I mean, Amy Coney Barrett will be the only justice on the court who did not go to Harvard or Yale. And so she went to Notre Dame Law School. So just from that perspective, she's actually pretty different in addition to her age, and she has small children and so on. But she is actually a step in a different direction in terms of her background.
And do you think she's going to make a big difference in terms of the court?
I do think she's going to make a big difference. And I mean, she has made no secret of the fact that she follows the same approach to judging that Justice Scalia himself followed. There's some reason to think she may even be more of an originalist than Justice Scalia was. I think she could make a very big impact on the court. My own personal politics and judicial philosophy are very different than hers. And I had the view, as I think many people did, that there shouldn't be a nomination at this point. There should be a nomination after the election. That was my very strong view. As for Amy personally, though, she is a hardworking, compassionate, lovely human being. And so, I have some hope that although her approach to judging, I think, it can be very harsh, that she is a person who will understand the human side of what she's doing. And it remains to be seen how that will play out in her judging. But she could definitely have a very big impact for a very long time.
So you mentioned that she's an originalist, and I wondered if you could explain a little bit about what that means in terms of a judicial philosophy, because actually, I think the case that you're involved with, which is now before the DC court, is relying on an originalist position.
It is.
To make its case. So talk a little bit about that.
Sure. So the basic idea is that the Constitution gets its authority from the people who ratified it. And so in order to understand what the Constitution means, we need to look at what the people who ratified it thought it meant at that time. So that's the gist of the philosophy. So she would look, and Justice Scalia would look, for example, at, they would start with the text, the actual words that were voted on. And they would try to understand those words based on how people understood those words at the time they were used. So for example, some people today argue that some of the founding documents said all men are created equal, not the Constitution. And now we think men means something quite broad, but at the time they clearly didn't think that all humans were created equal. Some humans were enslaved. Some humans were viewed as property. Some humans didn't have the right to vote. So they didn't understand that term to be all humans, even though we understand it that way today. And so that's the philosophy that that Justice Barrett will follow, that Justice Scalia followed, that to some extent Justice Alito and Justice Thomas follow. Justice Breyer has a very different view, and he understands the Constitution to be a living document that was adopted to establish certain principles of governing. And those principles of governing change in shape and size as the situation changes and the time changes and the view in the United States changes. So he understands the Constitution to be more of a kind of principles that are alive that can be interpreted rather than just what the framers intended. And he and Justice Scalia, actually, back to their friendship, they had a kind of a roadshow that they would do at law schools where they would debate this issue in front of law students. And Justice Scalia's line was always, well, you may think there's a living Constitution. I think the Constitution is dead. And that's how they would argue it, that it's dead because it meant what it meant, and that's not growing at all. It can only grow through amendment. So.
Okay, so you brought up the amendment, and that's the case that I was referencing. So you've been involved in with the Equal Rights Amendment now for a number of years. You were with the group that, I was with a group that first tried to get Illinois to adopt the amendment back in the 70s. And we weren't successful, but we do have an Equal Rights Amendment in the Illinois State Constitution. And now, in the last 3 years, now there have been 3 more states that have adopted the amendment, which in fact brings it up to the total number of states required for it to become the next amendment to the US Constitution.
Right.
Except that there was this, and this is the thing that they kept, slapping us in the face with, there was this time limit. So what is the argument that you're making now to overcome this time limit argument?
So the method to amend the Constitution is set forth in Article 5 of the Constitution. It provides this process that you may remember from civics class, that where the Congress
classes,
where the Congress can propose an amendment. It requires a 2/3 vote of Congress, and then the amendment is sent to the states for ratification by the state legislatures. And an amendment requires 3/4 of the states. And Article 5 says that when an amendment shall be valid for all intents and purposes when ratified by 3/4 of the states. So when the ERA was proposed in 1972, Congress included a 7-year time limit on the ratification. That time limit actually followed on a tradition that Congress had been following through most of the 20th century. So before that, there were no deadlines on amendments at all. Starting with actually the Prohibition Amendment, someone proposed a 7-year time limit, we think because they thought that that would make the amendment fail. And people didn't, the folks proposing the amendment didn't really want it to pass. Obviously it did, it passed very quickly, well within 7 years. The 19th Amendment, for which we've just celebrated the 100th anniversary, didn't have a time limit, but most of the other amendments proposed in the 20th century did. The thing that changed in the 60s and 70s is that the time limit was no longer included in the text of the amendment itself. So it wasn't part of what the states were voting on. Instead, it was included in the preamble. So the beginning of, if you look at the ERA, it provides that Congress proposes this amendment, which shall be effective for all intents and purposes when ratified by 3/4 of the states within 7 years. So 7 years obviously came and went in the 70s. The time limit was actually extended by 3 years by a simple majority of Congress in the late 70s. So it actually expired in 1982. At that point, we had only 35 states. About 10 years later, the 27th Amendment became part of our Constitution. The 27th Amendment has to do with congressional pay. And it is known as the Madison Amendment because it was proposed by James Madison. And it took 204 years to get to 3/4 of the states to ratify it. There's actually a wonderful story about how that came to be. There was a student who discovered this and wrote a paper about it and was like, you know, we're only a couple states away from ratifying the Madison Amendment. We should really finish that. And so he started to raise the issue with state legislatures. Apparently he got a C on the paper, but the Madison Amendment did end up getting enough states to carry it over the finish line. So the most recent amendment we have to our Constitution took 204 years to ratify. And that gave the ERA proponents an idea. Maybe instead of starting over with the ERA, which people had been proposing every year since 1982. There's been a new ERA proposed in Congress every single year. But after
it's not a new ERA, right? It's the same wording.
It's the same wording, actually with a little bit more. Okay. There's a little bit more added to it, partly because, you know, in the 70s, everyone said, put women in the Constitution. But the word woman isn't actually in the ERA. So they added it in the new one, but it's very similar. So that new one was proposed again and again and again. After the Madison Amendment passed, the proponent said, wait a minute, maybe we should just try to finish what we started and get the last 3 states to ratify. And that started what became known as the 3-state solution. Let's get 3 more ratifying states.
Okay.
Well, nobody was very interested in this outside of a few activists for a while, until the 2016 election and the Women's March, which really galvanized the women's movement in a different way. And with the energy from the Women's March, the state of Nevada, led by a really fantastic state legislator named Pat Spearman, ratified the ERA in what seemed to be a completely out of the blue thing. And then Illinois in 2018, and now Virginia in 2020. There are very active ratification efforts in many other states. My guess is that the next state to ratify will be Arizona, but North Carolina is also in contention with a pretty far along ratification effort. So there can be more. It's just that we only needed 38, and now we have 38. So what we're doing in this lawsuit that you mentioned is making the argument that a time limit that appears in a preamble that Congress put in a joint resolution can't change the basic process that the framers laid out in Article 5. So what we hope is that the court will look to the plain language and original meaning of Article 5 and say, no, there wasn't supposed to be a time limit. There's no room for time limits. Congress can't by itself change what Article 5 lays out as the process. And that's the main argument we're making in the lawsuit.
And so there's a national coalition involved in this, right? And
yes.
You're head of the legal end of that coalition. So does that mean you would be the one who would be arguing this in the court?
Well, unfortunately, probably not, although I would love to, and maybe there's a way for that to happen. But right now, so after Virginia ratified in January, the attorneys general of Virginia, Illinois, and Nevada filed this lawsuit that we've been talking about. So it's a federal lawsuit pending in the district court in Washington, D.C. And so they're the plaintiffs. And at this moment, they're the right plaintiffs, because you can't actually enforce the ERA for a couple years after it's been on the books. There's a delay built into the ERA so that states have a chance to get their act together and revise laws that might violate the ERA. So nobody can sue to enforce the ERA right now. But these 3 states believe they have a claim that will get the case into federal court so a court can rule on this deadline issue and a couple of other issues. And so that's what the lawsuit is. But the plaintiffs are the states. And certainly the coalition is working very closely with the states, but they are speaking for themselves. And I think that makes sense for where the case is now. My firm represented a coalition of 50 women's rights organizations, including NOW, Feminist Majority, the Black Women's Caucus, the National Women's Political Caucus, Time's Up, a number of other women's organizations in an amicus brief, a friend of the court brief in that case.
Okay, so we're in the middle of a pandemic, and and how do you argue a case in the middle of a pandemic?
Well, we're waiting for an argument date in that case, and I'm sure it will be on Zoom, just like this. We hold arguments on Zoom. The Supreme Court these days is holding arguments by phone, which I personally think would be really difficult to do, because then you can't even see the justices. But I've done a half a dozen arguments during the pandemic on Zoom. And I actually kind of like it because it's very intimate. Like you see the other justices or judges' faces. I've done a number of arguments before 3-judge panels. I did one in front of the Ninth Circuit, where they were all in California in different places, and it was 5 of us on the screen, the 3 judges and 2 lawyers. I did an argument very recently in front of the Wisconsin Supreme Court, and there were more boxes on the screen. But I kind of like that. I kind of like that feeling, and it makes it possible for lots of people to see what's going on. The whole issue about cameras in the courtroom has been really controversial for a long time, but you can, I think we're beginning to break through that because of this technology that we have to use in order to appear in front of courts. Now, I have to say there are some courts in some parts of the country that are still behaving as if the pandemic isn't happening. I actually am involved in a case that is set to go to trial in the beginning of December in East Texas, and it's a jury trial, and we are set to pick a jury on December 4th. I'll be attending as the appellate lawyer attending the trial, and apparently the judge has said that if you are speaking in the court, you are not allowed to wear a mask, nor is the jury allowed to wear a mask, because it's important in an in-person trial for people to see each other's faces. Now, fortunately, I will not be speaking, so I will be sitting in the gallery with an N95 mask on, trying not to get the coronavirus. But there are definitely some parts of the country that are behaving kind of business as usual in the courts. Illinois is not one of them.
I'm glad to hear that.
Yeah, me too.
Because I think I might turn down the jury notice if I were summoned in East Texas.
Well, you wonder who we're going to have on the jury. Yeah. And it is I was actually down there for meetings and hearings and things 2 weeks ago and came back and had to quarantine. So I haven't really left my house in about 2 weeks because of the quarantine requirement. So I assume I'll do the same thing when I get back from the trial, and hopefully I won't be sick.
I hope so too. So let me see if there's anything, any kind of story you want to share, or, oh, you were talking about a moot court recently. That's something I remember from television shows about student lawyers.
Yes. Well, lawyers always do. So I do a lot of appeals, and I always do a moot court because it's really the best way to practice. So I get my colleagues or my partners or my clients, and we actually have a courtroom in our law firm, and we use it for this purpose. And so I'll have people sitting on the bench, and they'll ask me questions and pretend they're the judges. And for these moots over Zoom, I've had them appear on Zoom, and we have all done a practice. But I recently did a moot court that was much more fun than that. It was a part of a fundraiser for the Shakespeare Theater in Washington, D.C. Every year, they do a fundraiser that it basically involves having two Supreme Court advocates come together to argue a pretend case in front of a panel of real judges, usually including some of the actual Supreme Court. And they base the problem, the pretend case that's being argued on a show that's being performed at the Shakespeare Theater. So 2 summers ago, I got to argue the defense of Mordred, the villain in Camelot. And Camelot was being performed as a musical in the Shakespeare Theater at that time. And the panel was Justice Ginsburg, Justice Breyer, Justice Kagan, a Supreme Court justice from Canada, and a judge from the DC Circuit Court of Appeals. And it was the most terrifying argument I've ever done, because the whole point was not to persuade anyone, it was to be funny. And what I was told is that I was the one who was supposed to be mostly funny, and the judges were there for show. That's what I was told. So I had to write. I mean, I spent more time preparing for that argument than I've spent preparing for most. I wrote jokes. It was quite a thing. And it was really, really, really fun. And I argued against Noel Francisco, who until very recently was the Solicitor General of the United States, representing Donald Trump's administration in the Supreme Court. So it was actually very funny. This was, he actually made jokes about the size of the crowd. And at one point, Justice Kagan, he was pretty funny. And at one point, Justice Kagan, of course, I made a lot of politically edgy jokes. And at one point, Justice Kagan said to Noel Francisco, "Does he know you're here?" And Noel Francisco said, "I hope not, or else I won't be here tomorrow." So, but anyway, it was great fun. It's actually on C-SPAN. If anybody wants to see it, just Google Justice Ginsburg Camelot, and you will see the footage of this event. But it was one of the funnest things I've had an opportunity to do in my career.
Okay, so we've gotten at least one question in the chat room here. And Aaron, can I ask you to let Agatha Gallo ask her question?
Absolutely. I could have listened to you guys talk forever. That was wonderful. Let's see. Agatha, do you want to ask your question? I just asked you to unmute. You just have to unmute yourself and you can talk away. Hello.
No, I was just wondering if you can comment on the Supreme Court and the Roe versus Wade issue and what you're thinking at this point.
Well, I think we're at that position that we wondered whether we would be at for a long time, which is we have enough votes to overturn Roe v. Wade now on the Supreme Court. That doesn't mean that they will do it. And it doesn't mean that they will do it soon either. Because in order for a case to get to the Supreme Court, you have to go through a number of different courts and people need to appeal. I mean, it needs to be a real case. And it needs to be something that someone has asked the Supreme Court to review. And the Supreme Court turns down a lot of cases. As I mentioned, the vast majority of cases aren't granted. But I think it's certainly reasonable to think that the Supreme Court would be open to reversing Roe v. Wade today in a way that it hasn't been. Now, at the same time, most of the decisions we've seen in the last 15 years maybe have been much more incremental than that. So basically what happens is a state enacts a rule that is a limit of some kind on abortion rights, like a waiting period or a requirement. The case that came up recently was a requirement that an abortion center satisfy certain kinds of hospital medical requirements that made it virtually impossible for abortion centers to exist, and reduced in some states the availability of abortion dramatically. And so for each of those cases under existing case law, the court would decide whether the rule or law imposed an undue burden on a woman's right over her own body. And that's a very flexible, sliding kind of analysis, because the court didn't say you have a right to abortion for 9 months to do whatever you want with your body. The court said we have to balance the different rights at issue here, and this is the way we're going to try to do it. So what we've seen mostly in the last 10 or 15 years is just incremental restrictions on abortion being upheld, rather than the court just overturning it. And even Justice Scalia in a number of cases said, no, that's the law, so we're going to apply the law to this new thing. So I think, I do think it's possible that Roe v. Wade could be overturned. And that was the whole point of the appointments that have been made. I mean, that's what the president promised us. He would appoint people like Scalia, and he would appoint judges who would reverse Roe v. Wade. So I think it's possible that that will happen.
So is there any interplay possible between if the Equal Rights Amendment gets into the Constitution and Roe v. Wade? Is there any?
Well, that's a really interesting question, and it depends on who you ask. So there are some proponents of the ERA, and particularly Republican ones, who say there's really no relationship between the ERA and abortion rights. And in fact, some of you may know the name Steve Anderson. He's a really, really wonderful legislator from Illinois who played a role in the advancement of the ERA in Illinois. He was a really critical advocate for the ERA. And he's now actually joined the board of the National ERA Coalition and spends most of his time going around educating people about the ERA. But he would tell you that abortion and the ERA are not linked. And my view is there will certainly be arguments made by abortion rights advocates that implicate the ERA if it exists. But it's much broader than just abortion. And some of the current opposition to the ERA is really about abortion rights. And it's been framed as, you know, this will instantly legalize abortion for 9 months in all 50 states. And I actually don't think that's true. I don't think there's any reason to think that abortion rights under an ERA would be broader than they currently are under Roe v. Wade. But you know, one thing is for sure, which is that advocacy at the state level becomes more important. I mean, as you may know, Illinois has a law that says that even if Roe v. Wade is reversed, Illinois will continue to make sure that abortion is safe and legal. And so in some ways, I think what Justice Barrett's appointment is going to do is kind of shift the role of the Supreme Court so that we're no longer able to rely on the Supreme Court as the place that rights get recognized. We're going to have to kind of go back to the states and start talking about changing state legislatures and state laws to make sure that rights are recognized.
Which is what a lot of people believe they think the states should make their own laws and not have the whole country deciding on it.
Yeah, and that's the argument. I mean, that's the argument against the policy argument against something like Roe v. Wade.
Linda Bonner has a follow-up question. Linda?
Nope, it's Dennis. I'm standing.
Dennis, you tricky trickster.
We look very much alike over Zoom when you can't see us.
You really do.
I guess I'm asking the question, since I don't know quite the Supreme Court works. Let's say the worst case scenario happens and they do reverse Roe versus Wade. Does that mean that that then is cemented in place forever, or could that reversal actually be challenged and be reversed back again by another court that's more liberal in another time?
Well, it could be, but I think that would be very unlikely and it would take a very long time. And if you think about how long people have been criticizing Roe v. Wade since it was first decided.
Right.
And they've been criticizing not only the outcome, but also the reasoning. I mean, I was taught in law school that there were some problems with the way Roe v. Wade was analyzed, and that the Supreme Court over the years developed a more robust rationale for the right that it found in Roe v. Wade in the later cases like Casey and other cases that involve reproductive rights. But the Supreme Court has this concept that you may have heard about called stare decisis, and it's a legal rule that recognizes that once the court resolves something, it really mostly should be resolved. And that we don't want, it's not good for the institution of the court for it to swing back and forth just because there are more liberals or more conservatives. So in order to overturn a prior decision of the Supreme Court, there's a special analysis that the court goes through to evaluate, like, is it a decision that's been consistently criticized? Is it a rule that has proven to be unworkable as a practical matter? And is it a rule that people have relied on? So, for example, I think if you think about the same-sex marriage decisions, yes, we have a conservative majority, but I think it would be really hard for a conservative majority to conclude that the same-sex marriage decisions should be overturned, because people have acted in reliance on those decisions, like quite a lot of them actually, right? And so, and they haven't proven to be unworkable. And frankly, they haven't really been criticized that much. So I think it would be very hard for the court to reverse those decisions under the principle of stare decisis. Roe v. Wade is maybe a little different because it has been criticized all this time. And this is why in the confirmation hearings for Amy Coney Barrett, there was a lot of conversation about stare decisis and how she regards it. It's a little bit in the eye of the beholder. Kind of, it is what you want it to be. So is it something that the court could get around? Definitely. But they do actually, as a matter of practice, go through that analysis before they reverse a prior precedent. They went through that kind of analysis in Brown versus Board of Education and in other cases that reverse decisions from many years earlier.
Susie, you have your hand raised. Let's see what you have to say or ask.
I was curious during the election where they proposed adding another Supreme Court justice and how unusual that was. And what do you think about how, if that would ever happen?
Well, I think it could happen. And it's actually something we've been discussing a lot at my house because my daughter, whose birthday is today, is going to be a poli-sci major, and she is working on an exam as we speak in which they are discussing different reforms that could be created for the different branches of government that would make them more democratic. So I've been talking about this issue a lot. I think the idea of adding justices to the court is actually not a brand new one. You may remember reading about the court packing plan during the New Deal. And some people thought that the threat to add a lot more justices actually influenced the court to begin changing how it voted on some of the new initiatives that were happening in the New Deal. And I'm not sure that theory is quite right, but this is not the first time that people have talked about adding justices. I do think that there is more, the way we appoint justices is different today. Justice Scalia was approved either unanimously or almost unanimously. Justice Ginsburg was approved by the Senate either unanimously or almost unanimously. Same with Justice Breyer. It was really not until Justice Bork that the Senate started really scrutinizing the substantive legal views of the nominees. And then you end up with this dance, right? Where the judge says, well, I can't really talk about that, can I? And then everybody gets mad and said, so that's like a dance that's been going on now for a while. But this isn't the way it used to be always. And so I do think it's the case that there is more politicization of the nomination process. And also we have justices who, who are old, right? and they're, Justice Ginsburg, like the fact that the fate of rights of a lot of people depended on whether an 87-year-old woman who had had pancreatic cancer and multiple other kinds of cancer over her life could continue to work another year was like, that's a crazy situation. So there are some reforms that are being talked about that are more like term limits or kind of rotating the right to do nominations and that kind of thing. I do think all of these things are going to be under consideration. I'm actually glad that there have been no firm commitments on this issue at this moment, because by President-elect Biden, because I do think it's something that's going to require some study and thought, because I think it's a complex topic and it hasn't really been top of mind for a lot of people for a while. So I think it's an important and interesting topic.
So is there anything in the Constitution that spells out, other than the fact that there is a judicial court, that spells out how it's shaped?
No, it's actually an act of Congress that does that.
Okay.
So the existence of the Supreme Court comes from the Constitution, and the powers of the Supreme Court come from the Constitution. But there have been a number of acts of Congress that have really fleshed out what that looks like, the way, how many justices, how the courts of appeals work, the rules, all of those kinds of things. That all comes from Congress.
Okay.
So it would not require amending the Constitution, which, as we know, is very difficult.
Okay.
I really liked when you were talking about when you were clerking and how everyone, the State of the Union address, they would go and have dinner together and stuff. I feel like that puts a more honest face on the relationship of the Supreme Court justices. I feel like they have gotten very TMZ'd,
Yes.
where where maybe the truth isn't, and they probably don't have time to be like, well, actually, we're all very good friends. So it's really nice to hear some truth as to what that world really is like.
Well, and I can say a little bit more about that. I mean, when Justice Ginsburg passed away, I watched the funeral it wasn't the funeral, but it was the part that was actually in the Great Hall, and the justices were there, all of them, with their many of them with their spouses, and I had an emotional reaction to that, because I know how deeply grieved they are feeling right now. I mean, they've been working with her for decades, and they feel a real sense of human grief, all of them. And she made that clear when Justice Kavanaugh joined the court. Justice Ginsburg came out very quickly and said, we embrace him. And I believe that's true. And they will embrace Amy Coney Barrett, and they embrace Justice Gorsuch, and they really believe that. And it gives me a little bit of hope. They also just enjoy each other. I mean, two of my favorite traditions of during my term at the Supreme Court the first was the Christmas party. By the way, it was not a holiday party. It was a Christmas party. And it was put on by then Chief Justice Rehnquist, who had a songbook of Christmas carols. And the justices would come with their spouses, and all the clerks were there with our spouses or significant others, and the people who work in the court and the Capitol Police and the custodians and the women who work in the elevators and all this. Everyone's at the party. And there was a judge, Eddie Becker on the Third Circuit, is a pianist, and he would come in and play the piano for the Christmas carol sing, and the chief would actually conduct. And in the middle of the Christmas carol sing, it was traditional to sing G Officer Krupke.
Oh.
And Justice Scalia did the one, I'm psychologically disturbed. I mean, it was something. And then at the end of the term, it's traditional for the clerks to do a musical theater sketch comedy performance for the entire court. And there were a couple of us who had sung in a cappella groups in college, and Justice O'Connor learned about it. So she told the chief, who ordered me and two others to be in charge of the skit.
Sure.
And so we wrote songs, and we, of course, it was a send up of the justices, of course.
Mhm.
And I got to play Justice Ginsburg, and I got to wear her actual robe.
Wow.
Which
Did you
was
wear the
very
collar,
formal,
the lace
and I wore a
collar?
collar, and I wore glasses, and I had my hair up, and I was very, prim and serious, and anyway, and I was terrified because she's a lovely person, but Justice Breyer and Justice Thomas would sit in the front row and just laugh uproariously at the entire thing. Justice Ginsburg was always a little more serious and not a big laugher. And so I was terrified. And she came up to me afterward and she said, "That was very nice, dear."
High praise. That's great.
But it was warm, it was funny, it was people really enjoying each other, and that's how they work together. And I think, the court speaks only through its opinions. That's its only official act, and they care a lot about that.
Mhm.
So they don't do, they do make speeches and they write books and stuff, but that's the only official speech of the court, is when they write the decision. And so I think it's helpful to think about them as human beings, because they really are, and they interact that way with that kind of mutual respect.
Awesome. All right, this is your last chance, audience. If you have a question or a comment, pop it up now. Oh my goodness, Janet Barkley.
Hi. Whenever states' rights comes up, I always pause to think about what would have happened with civil rights, with the rights of Blacks, if you left it to the states. There would be states that would still have Jim Crow laws. So help me, I guess, to understand the efficacy or whatever of states' rights versus federal rights.
I think this is the big change that we're going to see with a conservative majority Supreme Court. And that is that the Supreme, for a while now, since the Warren Court, the Supreme Court has been kind of driving forward civil rights ahead of where the states were, certainly ahead of the states, even ahead of Congress in some situations, right? And so we saw that, we saw that with abortion. We certainly have seen that with same-sex marriage. There are other ways to get stuff done. And one way is through the states. And, as Marianne mentioned, Illinois had an equal rights amendment in its own constitution when it adopted a new constitution in 1980. And it was kind of weird that was the case. And yet Illinois was the kind of last stand of the equal rights amendment in the early 80s with Phyllis Schlafly and all this. And we didn't do it here until decades later. But you can have states legislate. You can also have Congress do quite a lot. And the Voting Rights Act, it was actually the Voting Rights Act that really did away with Jim Crow. And that was an act of Congress. Now it has been cut back, but but it was an act of Congress. And healthcare, the Affordable Care Act was an act of Congress. And if you were reading the commentary this week, many people concluded from the argument, and I wasn't surprised given what the issues are, that this Supreme Court is likely to uphold the Affordable Care Act again. So there are still things Congress can do. And I think we're going to see more conversation about that. There may be, I think there's a really good case to be made for a new Voting Rights Act, or for a revisited Voting Rights Act, for a new or expanded Violence Against Women Act. And this is actually one of the important things about the Equal Rights Amendment. The Equal Rights Amendment itself has 3 sections. The first one is the one we all know about, the 24 words, right? The second one actually expands the power of Congress to legislate to serve the rights guaranteed by the first clause of the Equal Rights Amendment. So the Equal Rights Amendment, if it were to become part of the Constitution, would provide an alternative basis for power for Congress to do stuff. Because right now, Congress can only do what the Constitution says it can do, right? So most of what Congress does today has to be linked to the commerce power, interstate commerce. And the Supreme Court or the Congress has stretched that pretty far, and has done a lot of stuff through the lens of the commerce power. And some courts have started to cut that back. But the Equal Rights Amendment is a potential alternative source of power, sort of like the 14th Amendment was. And that was the basis for the Voting Rights Act.
Awesome.
I know you have to your daughter's birthday party soon, so I really want to thank you for this conversation, because I'm just
thank you.
Enjoyed it.
Yeah,
thank you so much. I really enjoyed it too.
Do either of you have a last comment or statement to make before we sign off?
Well, I'm thrilled to have had this conversation, and I know Marianne has worked for so many years on many of the same issues, so it's a real thrill for me to have had the opportunity to get to know her, and I'm really happy to have spoken with all of you. I also can assure you that this is going to be an extremely small birthday party.
Thank you. Thank you for
which is too bad, but that's where I hope you all remain safe and healthy and hang in there through this pandemic.
Well, thank you all so much for coming tonight. I just want to thank Marianne and Linda one more time for coming to Notable Neighbors. We do have programs every Monday at 1:30 via Zoom. And so if you haven't, please look at our website, www.19thcentury.org. And if you want us to continue putting on these amazing programs, think about giving a little donation. And you can also do that right on our website. For everyone at the 19th Century Charitable Association, I'm Erin Payton, and I hope you all have a wonderful, safe evening. Good night.
Good night.